Hello, welcome to this video presentation entitled Minority Labor Arbitrators, Issues which Arbitrators Face. I'm Howard T. Spence. I am an arbitrator and attorney who practices primarily in the state of Michigan, but I do work nationwide. I also do mediation work and I do training and consulting work. I am associated with Black Gold Associates LLC and Spence and Associates, which are the firms which I utilize for my arbitration, mediation, and legal services business. I should start out by saying that every judge has an opinion. I am formerly an administrative law judge, and of course I have an opinion, and I just want you to know that the opinions which are expressed in this presentation are my opinions only, and they do not necessarily represent the opinions of any arbitration panel or association on which I serve, nor do they represent necessarily the opinions of any other arbitrator. I do want to acknowledge also that some of my opinions may not be absolutely correct. I'm open to discussion and reconsideration of opinions. I have put together this presentation in hopes that it will engender some thought and some ideas and opinions from those of you who are in the audience. This particular presentation is one of a series of presentations which I put together dealing generally with the topics of alternate dispute resolution, and in particular dealing with some of the problems, issues facing minorities and females as they attempt to enter this profession. Overall, it is my hope that after a dialogue and discussion of the topics which are presented in these various video presentations, there will be a movement toward greater inclusiveness and greater diversity within the profession of alternative dispute resolution. Overall, the series consists of 6 different segments. The first series segment deals with an introduction to the topic of alternate dispute resolution. In that segment, I look at some of the distinctions and differences between mediation and arbitration and other forms of dispute resolution. I also look at some of the differences between the types of arbitration. For example, I will attempt to highlight some of the differences between the practices of employment arbitration and labor arbitration. The second segment of this overall presentation series deals with the topic of why parties elect to arbitrate their disputes rather than litigating them in the courts. In that particular segment, I look at some of the factual data and opinion information which has been collected, which shows why there has been a tendency and a trend over the past 20 or 30 years for more and more companies and individuals to take their disputes to alternative dispute resolution rather than to the courts, circuit courts, whatever, where they have traditionally attempted to litigate and resolve their disputes. In the third segment of this presentation series, I look generally at the topic of why become an arbitrator. In that segment, I attempt to highlight and point out some of the compensation benefits from being in the profession, some of the professionalism and esteem benefits. Generally, I attempt to provide information that will help people to understand and to encourage them to consider moving into this particular profession. The segment which you are looking at today is actually the fourth segment in that presentation series. This segment deals with some of the issues in arbitration which are faced by minority arbitrators as well as other arbitrators. There is a fifth segment in this presentation series, and that segment deals with the process of making decisions and writing awards. how do arbitrators go about actually deciding the cases that come before them. The final segment of this presentation series, dealing with diversity in the arbitration profession, deals with becoming an arbitrator. In that segment, I look at some of the qualifications as well as the screening process for appointment to the panels where arbitrators go to find their work. In addition, in that sixth segment, I take some time and I discuss and highlight the process that I actually went through myself during the application process to become a member of the American Arbitration Labor Arbitration Panel. There are quite a few hoops to jump through before you can get on a labor arbitration panel. I think that many of you are already aware of that fact, and in my discussion of the hoops that I had to jump through, I'm hopeful that I can provide information to you that will make your journey towards becoming a labor arbitrator just a little bit easier and more logical for you. Today's topic: issues faced by arbitrators. I have outlined a number of issues which I believe are important and which are faced by not only minority arbitrators but by arbitrators generally. Because of the breadth of the topics, I am not looking at attempting to answer any of the topics in any great detail. In fact, I have to confess that there are some of the topics or issues which I raise where I'm not quite sure of what the best or most appropriate answer would be. Hopefully, in a dialogue which occurs between you, me, and our colleagues in this profession, we will come to a better understanding of what might be the best practice or the best answer to some of the questions which I am raising in this particular presentation which you're looking at today. Also, because of the extensive breadth of some of the issues that we're looking at, I have broken this particular presentation down into 3 separate segments for purposes of video recording. The purpose in breaking down this particular segment into the 3 parts was to make it easier to upload the video so that it would not take as much of your time to review, and you would have the luxury or opportunity to select the topics which you want to look at in more detail and perhaps revisit them. This first part deals with 3 topics relating to issues faced by arbitrators. One deals with control of the hearing process itself. Another part deals with the role of the arbitrator. And the third part in this first part deals with dealing with bias and conflicts of interest. Overall, in this presentation, the topics which we're going to be looking at are control of the hearing, the role of the arbitrator, dealing with bias and conflicts of interest, when the arbitrator gets sued or dragged into court, some of the issues and topics relating to business and operational issues for arbitrators. We're going to deal with the topic of disclosure issues, and we're also going to take some time to look at the topic of race and ethnicity in the arbitration decision-making process. Dealing with the topic of control of the hearing, I like to say that sometimes achieving justice requires a sharp sword as well as a balanced scale. Controlling hearing participants. In the arbitration process, just like in any litigation process, you have the parties, you have their advocates, you have the judge or the arbitrator, and you have the witnesses. And each of those different types of actors in this process can present a different set of challenges to the arbitrator or decision maker. In this particular topic of controlling hearing participants, I would point out that sometimes as an arbitrator you're going to run into an advocate or a party who attempts to intimidate the arbitrator or some other advocate or party in the proceeding. This type of bullying activity by a player in the arbitration process can be disruptive. It certainly can attempt to undermine the authority and control of the hearing process which an arbitrator attempts to demonstrate. Asserting authority over the advocate or party who fails to comply with orders for discovery or subpoenas issued by the arbitrator also is a variation of this theme and shows that the skills and actions of the arbitrator can really be challenged, especially if the arbitrator is a minority or female. It's been my observation that in some instances this type of bullying or disrespectful behavior in the arbitration hearing process comes from individuals who are not willing to provide the appropriate degree of deference or respect to the arbitrator or to the other parties. And sometimes that lack of deference or respect can be attributed to the fact that those individuals may, at least subconsciously, have problems accepting the authority of the arbitrator. I want to take a moment to highlight some of the topics and issues relating to handling the aggressive or emotional party, witness, or advocate. Maintaining decorum and respect in an arbitration forum can be much more difficult for an arbitrator than for a judge in a court setting. In part, the reason that an arbitrator may have difficulty controlling a hearing which a circuit court judge would not have derives from the fact that the circuit court judge has authority embedded in statutes or court rules which an arbitrator may not have. For example, a circuit court judge can apply sanctions, including even incarcerating individuals or having them held in contempt for misconduct or poor behavior in the hearing process. By and large, an arbitrator does not have such authority to hold someone in contempt. There are possible tools or sanctions available to an arbitrator to control the hearing and to enforce the arbitrator's awards, and we're going to take a moment and consider what some of those tools or sanctions might be. What do the rules indicate about sanctions or the authority power of the arbitrator? Almost all arbitration hearings are actually conducted pursuant to a set of rules. In many cases, those rules are actually promulgated and adopted by the parties after an association, for example, the American Arbitration Association or FINRA, puts the rules together and provides them to the parties for the control of their hearing. Should misbehavior by a party or an advocate impact the arbitrator's ultimate decision in a case? Should the arbitrator default a recalcitrant and non-cooperating party? And should an attorney advocate be reported to the State Bar Association by the arbitrator for observed misconduct or unprofessional behavior in the hearing? Each of these questions suggests a possible tool that could be used by the arbitrator to control the hearing process and to maintain the appropriate amount of decorum in that process. As I indicated, the various arbitration associations have promulgated rules which may give guidance and control authority or possible sanction information available to the arbitrator. In the American Arbitration Association rules, there are suggestions for power and consequences for violation by the parties of those rules. Any special or specific hearing procedural rules in the contract or the collective bargaining agreement should also be considered and used. In most hearing settings, rules of evidence, generally the arbitrator follows the rules of evidence, but the arbitrator has some discretion in determining what evidence to admit and what weight to give to the evidence which is admitted. The arbitrator does issue orders during the course of the hearing proceeding. Those orders set parameters and guidelines for the parties. Also, there are stipulations of the parties as to how the proceeding should be conducted. If the parties provide stipulations about the procedures and process to be followed, and if those stipulations are accepted by the arbitrator, then those stipulations also become binding on the parties in terms of deciding how the contested case will proceed. The stakes and emotions related to arbitrations can run quite high. Many times arbitrations occur when parties cannot resolve their disputes through negotiations or mediations. Quite often in arbitrations there are significant financial consequences or considerations raised. Many arbitrations involve decisions which have the impact of big bucks. And some arbitrations occur as a result of parties wanting to proceed to be vindicated based upon what they consider to be matters of principle. It's good to recognize the fact that by the time these disputes get to arbitration, the parties have already many times attempted to resolve their disputes through negotiations or mediation. By the time these matters get to arbitration, the less intense and less emotional and less significant cases quite often will have already been resolved and taken out of the contested case process. Arbitrators are often called umpires or referees, and that's for a good reason. It's important to understand and remember that the skill set that an arbitrator uses to deal with recalcitrant and aggressive parties often differ from the skill set which is used or are used by mediators. Arbitrators must make fair and impartial calls, and arbitrators have to get it right most of the time. Even if you are fair, if you don't get it right, pretty soon you will no longer be involved in the business of arbitration or in the profession of arbitration, because the parties will prefer to utilize arbitrators and individuals who, for the most part, can get it right. Parties are accustomed to resolving disputes by litigation. As I indicated earlier, over the past 20 or 30 years, there has been a steady and accelerating process of resolving disputes through alternate dispute resolution, arbitration, rather than in litigation in the courts. Especially in the area of labor arbitration, it's important to understand that sometimes the dispute which is being resolved by the arbitrator is only a part of the problem or goal of the arbitration. In the labor setting, one of the main focuses of arbitration is to provide a fair and neutral setting which will allow for the workplace to maintain a certain degree of peace and justice. I like to refer to the statement by Dr. Martin Luther King, Jr. True peace is not merely the absence of tension, it is the presence of justice. And in the labor arbitration setting, that is especially true. For an arbitration to be successful, it should contribute to the resolution of the dispute, and it should also contribute to the continuity of peace in the workplace. The second topic or series of issues which I want to address in this presentation deals with the role of the arbitrator. And for most purposes, it's appropriate to think of an arbitrator as a private judge or a judge for hire. The role of the arbitrator is essentially the same as the role of a judge in civil litigation, except that the parties select the arbitrator where they don't have the luxury of selecting a judge, and the parties also pay for the arbitrator, whereas the judges typically come free, so to speak, because they are paid for by the citizens through taxes. The role of the arbitrator I like to summarize in terms of three separate distinct responsibilities or duties. The judge serves as a neutral and impartial fact finder and decision maker. The issue of neutrality and impartiality is crucial for the arbitrator. The arbitrator controls the hearing process, and the arbitrator is responsible for developing a hearing record which will become the basis for decision making in the contested case. And finally, the arbitrator is responsible to issue a reasoned and thoughtful decision or award following the hearing. Arbitrators are almost constantly involved in a balancing act during the conduct of a hearing proceeding. The arbitrator has a responsibility of balancing between being fair and being completely neutral. And as I'll discuss a bit later, sometimes there is a distinction between being fair and being neutral. An arbitrator, in the course of controlling the hearing and in the course of moving towards an ultimate decision in a case, must many times use his or her discretion on issues or problems which can be decided either way. That's why they call the arbitrator a judge. He is responsible for using his judgment and his discretion in an attempt to come out with a result which is perhaps fair, certainly neutral, and consistent with the agreement of the parties, the contract, whatever it is that the arbitrator is attempting to construe and apply. The other side of the use of that discretion deals with the concept of abuse of discretion. While using his discretion or her discretion, an arbitrator must be careful not to cross the line and to apply that discretion in a manner which is abusive. Abuse of discretion is one of the few bases for the award or decision of an arbitrator being reversed on appeal. An arbitrator who gains the reputation of abusing his discretion or her discretion will also very likely not be successful in the profession of arbitration, and his days as a professional arbitrator, they're probably numbered. Another topic or question which arises in terms of the control of the hearing is how formal should the hearing process be? I've somewhat broached this subject a bit earlier in terms of fairness and neutrality, but there also is the issue raised about whether or not there should be any discretion or leeway given by the arbitrator in favor of a party who is not well represented in the proceeding. Not all parties have the same competent representation in the hearing proceeding. Not all parties have the same power to present their cases. An issue arises as to what then is the role of the arbitrator in terms of maintaining a fair hearing proceeding and in terms of balancing the ability of each of the parties or all of the parties to present their cases in the best possible manner. In terms of the arbitrator's duties and responsibilities in the process, I'd like to take a look at three questions. The first question, should an arbitrator attempt to encourage settlement during the hearing process? The second question, should an arbitrator accept the invitation of the parties to attempt to mediate a dispute which has already been submitted to arbitration? And the third question is, should an arbitrator aggressively move the process along to hearing and decision in face of foot dragging by one or more of the parties? Settlement is always an option in the arbitration process, just as it is in any type of litigation. The rules of most of the arbitration associations encourages settlement, and indeed, in many instances where the parties agree between or among themselves about an issue or a matter or an outcome, the arbitrator is pretty much constrained to accept that settlement or stipulation and to allow that to become the decision or rule of the arbitration case itself. The second question about whether an arbitrator should accept the invitation of the parties to mediate a dispute already submitted to arbitration is one where there will be a difference of opinion observed among arbitrators who look at that topic. The situation sometimes arises where the parties go to arbitration. Perhaps a mediation has earlier failed, or they haven't attempted to negotiate the matter prior to the arbitration. But after the arbitration hearing actually begins, one or more of the parties may reconsider their position. Perhaps they've had a chance to observe a witness for the first time, or they've had a chance to look at some evidence that they may not have been aware was going to be presented as forcefully as it was. But for whatever reason, once the hearing has started, they say, well, maybe as a result of reconsidering our position, this would be a good time to see if we can't settle or negotiate or mediate this particular issue or problem or case in whole. And sometimes, because they're already there, rather than adjourning the hearing, the parties will ask the arbitrator if the arbitrator is willing to mediate and attempt to resolve the dispute at that point. Sort of, let's stop the hearing and let's start a mediation. I myself am not a proponent of an arbitrator who has already started to arbitrate a case, changing hats or roles and becoming a mediator. I do mediation as well as arbitration, but I think that there is a significant problem or danger involved where an arbitrator agrees to mediate a case that has already been submitted to the arbitrator in the arbitration setting. The issue arises, what will the arbitrator do if the mediation that begins in the middle of the hearing is not successful? The parties may have been over-optimistic about their ability to resolve this particular dispute, and now we are in a situation where we're having to go back to the contested case or arbitration setting. And at that point in time, if the arbitrator has assumed the role of mediator, the arbitrator may have been exposed to information, evidence, private thought processes which the arbitrator would not have seen or been aware of if the matter had proceeded as a typical contested case or arbitration. And no matter how professional an arbitrator may be, it's difficult to put information that you have received in confidence out of your mind as you proceed to move forward to actually resolve a dispute. So the arbitrator who has agreed to become a mediator and then finds out that he is required to go back into the role of an arbitrator or a judge may have some difficulty at that point in time in his own mind or in the minds of the parties to provide a neutral, fair hearing. And there also will be the issue of whether or not any decision which results from the outcome of that arbitration process after the interlude for mediation is actually based on what is in the record rather than what the arbitrator may have surmised, picked up during confidential discussion in a caucus or where the other party was not present. During mediation, of course, witnesses and parties are not sworn, and so information they're sharing is not necessarily of the same value in a contested case proceeding as sworn testimony of a witness. So there are all these issues which are raised and which cause me in my own mind to think that an arbitrator should probably avoid agreeing to switch hats midstream. Certainly if an arbitrator decides that he or she is competent to do that and the arbitrator elects to do that, the arbitrator would need to advise the parties of the potential downside and dangers to the arbitration process which could result if the arbitrator agreed to mediate this matter at that point in time. The final question raised about the arbitrator's duties and responsibility in the process. Arbitrators typically find that one, sometimes both of the parties don't really want to move ahead to a decision and that there is foot dragging. Perhaps it is to the advantage of one party or the other not to get a quick decision. Maybe until a decision comes down, a party can continue a practice that would have a financial benefit to the party. So it is again a judgment call. It is again utilizing a set of skills to control the hearing process, to move the process along, to move the hearing along without appearing to be inconsiderate of a party, without considering or appearing rather to be less than neutral. The next topic I want to look at briefly is the topic of the arbitrator's demeanor, how the arbitrator conducts himself at the hearing. How should the arbitrator deport him or herself at the hearing? What respect or deference is due to the arbitrator from the parties? Avoiding fraternization or ex parte involvement with the parties. And then the degree of deference or respect that the arbitrators should show to the parties and their advocates. Along with the financial compensation, some arbitrators enjoy having the parties admire their decisions and admire them. It goes with the role of power or authority, and it's an additional benefit to the job or the profession of being an arbitrator. As long as the arbitrator doesn't take it to extreme, that's not a problem. Arbitrators shouldn't be haughty, aloof. They shouldn't look down on the parties. And the arbitrators should also understand that the arbitrator has been selected by the parties to resolve what the parties consider to be a serious dispute. Many arbitrators in their prior lives were judges. I myself was an administrative law judge for the state of Michigan for 10 years. And as a judge, you're used to a certain amount of respect and deference, which is to be expected as a part of the decorum of a courtroom or a hearing room. And the same thing is true here. Arbitrators expect and feed off of the admiration and deference of the parties. At the same time, the arbitrator needs to show a certain degree of respect towards the parties who appear before the arbitrator. The next topic I want to talk about is one that sometimes you don't see discussed very much when people are talking about issues of arbitration, and that's the topic of should an arbitrator examine witnesses to develop a full record. As I indicated, I have 10 years of experience in Michigan as an administrative law judge, and in Michigan as an administrative law judge, I had statutory responsibilities in many cases to assure that the record which was developed, which could possibly be reviewed in the appellate courts, that record needed to be full and complete by statute. And sometimes parties don't develop a full record. Sometimes you're dealing with novice advocates or advocates who haven't really thought through a case, or sometimes you're dealing with situations where the parties just don't get the information, the evidence, the testimony on the record which an arbitrator may need to issue a meaningful and lawful decision. I think many of you may have been in situations in either the courtroom or in an arbitration setting where you see the judge or the arbitrator sitting there looking like the arbitrator wants to ask a question, and the parties and the advocates are going through their examination of the witnesses. And this presents some issues and problems for the arbitrator. And in this particular presentation slide, you see the arbitrator sitting there saying, well, the grievant is not present. This case apparently had a grievant and he's not present, not listed as a witness. I wonder why that is. And then in the back of the mind of the arbitrator, as he's sitting there or she's sitting there all this time, they're saying, well, should I ask? That may or may not be an important question to answer for the arbitrator as he attempts to find a final decision in this case. Another example of how this type of pondering by an arbitrator may lead to an arbitrator wanting to ask questions of witnesses or the advocates during the course of the proceeding comes up with this particular suggestion. Here the arbitrator is sitting there saying, well, this witness said the guy was fired after he was gone for 30 days to have major surgery for cancer. And this is a discharge case, and no one has mentioned the Family Medical Leave Act. Should I ask why it is not a protected absence under the law? In addition to these questions which arise in the mind of the arbitrator and which the arbitrator may want to have answered so that the arbitrator can issue a decision with which the arbitrator at least is confident and satisfied, is the other side of that coin. Well, if I ask these questions, if they don't ask these questions of their witnesses, when should I ask these questions? And it's sort of a ticklish situation because it's a balancing act again that an arbitrator has to go through in the hearing process. The arbitrator doesn't want to disrupt the case of an advocate. And so as an arbitrator, you sit there, and not every advocate will present his or her case in the same way that you would if you were the advocate. And so you sit there wondering, well, for example, the issue of the Family Medical Leave Act, maybe they have another witness. Maybe this witness who's there now in front of me isn't the one who's going to testify about it. And so, but I really want to know. And once this witness is gone, if he is the one that has the answer to my question, what is the likelihood that we're going to be able to get him called back so that I can get the testimony I really want to have? And so the situation arises as to whether or not the judge or the arbitrator should interpose him or herself and ask these questions, which deal with what I like to call the elements of the case. You need to make sure that you address all of the elements or points of the contract which the arbitrator may need to have addressed in order to give a decision with which the arbitrator is comfortable. Another side of that same type of issue deals with the evidence which is presented. If the arbitrator is construing a contract provision, sometimes the parties will only give a part of the contract, and the arbitrator is sitting there saying, well, I have this piece of the contract which is an isolated provision in the contract. Is there some other part of the contract which also may be applicable, which this party may not have offered, that perhaps would lead to an entirely different decision if I was aware of it? And so the arbitrator is sitting there thinking, well, should I ask for the entire collective bargaining agreement or contract? Arbitrators interpret contracts. Many times the work of the arbitrator is simply to resolve disputes between the parties about the meaning and application of language in a statute or a contract provision. Arbitrators themselves get their authority to hear a case from a contract or collective bargaining agreement in most cases. Since arbitrators are responsible for construing or interpreting contract provisions, Again, do I have the entire contract that would allow me to see not only this particular phrase, but all of the other items or terms of the contract which may help me better understand how this provision should be used? Courts also have responsibilities for construing contracts or statutes just as arbitrators do. And the issue arises as to whether or not the decision maker, the arbitrator, the judge, should apply principles of strict construction to the contract or statutory language and terms. We often hear this philosophical argument or discussion occurring when people discuss the role of judges and the courts. Should judges be limited to strictly construing the language just as they find it, or should they be given some additional leeway to attempt to become more activist? Should the arbitrator be allowed to interpret the contract or statutory language in a manner designed to best effectuate the apparent intent or expectations of the parties when the contract or the collective bargaining agreement was negotiated and finalized? The approach of the arbitrator in terms of the philosophy of interpreting either contract terms or statutes can make a case turn 180 degrees. If an arbitrator only looks at the black and white language in front of him or her, you can sometimes receive a result or understanding which is very different from the result or understanding which you would obtain if you approach it in terms of what were the parties attempting to accomplish when they negotiated this particular language. And then again, you always have the question of what other provisions might there be in the contract which, if I was aware of those, would better help me construe or understand this particular provision. And sometimes, if you look at the contract as a whole, the provisions which explain or complement a particular contract provision may be significantly removed from that provision in the collective bargaining agreement or contract itself. You may have to do a lot of reading before you understand what this provision means or was intended to accomplish. And the same thing is true of a statute. You don't look at just one section or subsection. Sometimes you have to look at the rest of that particular part of the code in order to understand what this language itself means. Now, must an arbitration hearing result in fairness or justice? I've taught law courses in employment law, discrimination law, general business law, and one of the things that I often tell my students that takes them back a bit and sometimes surprises them is that justice or a fair result is not always necessarily the main goal of arbitration, mediation, or litigation in the courts. Sometimes what the arbitrator or the judge is bound to provide is a lawful result rather than a fair result or justice. When you're construing a contract term or provision as an arbitrator, and again, you are a human being, you have your own biases and view of the world, what you may determine a statute or contract provision to require, which is a lawful result, may be different from what you yourself would think if you had an opportunity to rule the world or to write the contract would have been a fair result. A lawful result does not always result in a disposition that is either fair or just. I think the topic that I'm attempting to explore here, or the issue I'm attempting to highlight here, deals with the question of whether arbitrations should be more like courts of law or courts of equity. Courts of law will look at a statute or a contract and apply the language. Courts of equity will not only look at the language or the contract, but will also consider what is fair and what is the best possible outcome in light of the goal of the court, which is to achieve fairness. Another topic which we really need to consider if we're going to be doing arbitration work is, should either federal or state laws be considered by the arbitrator, or should only the contract provision, which is the basis for the dispute, appropriate for consideration? Sometimes there are federal or state laws that regulate an aspect of the employment relationship. In fact, there are probably laws dealing with almost every aspect of the employment relationship. There's a Family Medical Leave Act, there's a Fair Labor Standards Act, there is OSHA, an entire group of laws that regulate the workplace, Title VII, the Americans with Disabilities Act. All of these employment and labor laws are there in the environment whenever there is an arbitration case which involves something going on in the workplace setting. And those laws may lead to different results than the terms of the collective bargaining agreement alone. And so the issue arises, if you are the arbitrator, should you look at only the contract language and apply that to the dispute of the parties? Or should you be aware of these other related federal and or state laws and utilize them to assist you with making a decision in a case? For example, if this is a discharge case, the contract may have language which says after 3 warnings you are automatically dischargeable or terminated, but that may lead to a result which is in conflict with another law that may preempt or take priority. Not all arbitrators will look outside of the contract language to apply federal or state laws which regulate the same area of dispute. In fact, especially in the labor area, historically, traditionally, a lot of labor arbitrators were not even necessarily judges. Were not even necessarily attorneys. And many of the very successful labor arbitrators historically would apply just the contract language, and sometimes they came to results which were not consistent with what an arbitrator would have achieved if the arbitrator had been aware of and applied a federal or state statute. So the overall issue which is presented in this particular slide and which must be considered is, should the arbitrator follow the contract provision or follow the law? Happily, 90% of the time, the contract provision and the law are congruent and they're not in any type of conflict. But when they are in conflict, how should the arbitrator proceed? Again, it kind of goes back to the topic we're discussing generally about the role of the arbitrator. As far as myself, with my background trained as an attorney coming out of the employment law area, if I was aware of the fact that an argument or an action in the dispute before me was inconsistent with a provision of law, and if the record supported that, I would likely apply the law and use the law to overrule what I see to be possibly an inconsistent or inappropriate contract term. And of course, if I were to write a decision, I would have to highlight that and provide my best understanding. This type of issue also underscores the fact that arbitrators sometimes are sitting there on the bench with these questions in their mind that it would be best to bounce off the parties and let the parties address, either through the testimony of a witness, evidence, or argument. And if I was in a situation where I was sitting on the bench as an arbitrator trying to determine the outcome of a contested case or dispute, and if I thought that there was a law that was applicable, such as the Family Medical Leave Act, then I think I would ask questions, possibly of the advocates, about whether or not, in their view, that particular law should have any impact on my decision. And at least I would have their feedback, and I would require them on the record to be aware of the fact that I was thinking of this law or the restrictions of a law, and give them an opportunity to show me perhaps why that law should not be a part of the consideration of the case which I present to them. Again, in the same type of control and role issue, sometimes the issue or topic comes up of should the arbitrator ask for evidence that the parties don't offer. Sometimes the parties expect the arbitrator to make a determination of the provisions of the contract, but they don't offer the entire contract or collective bargaining agreement. I've touched on that topic. And again, should the arbitrator specifically ask for or suggest that the parties provide the full contract or some other evidence or document? In some of the arbitration cases which I have chaired or heard, I have asked the parties or suggested to the parties that I would enjoy a more complete collective bargaining agreement or contract to help me as I attempted to resolve their case. And typically there is not a problem with providing that, although I do have to acknowledge that in one hearing where the entire collective bargaining agreement or the entire contract had not been offered to me, the parties resisted doing that. And since the case belongs to the parties, once I had indicated to them that there might be some value for me to have the entire collective bargaining agreement available to me, and they declined or were not receptive to that suggestion, at least they were on notice that I thought that might be an important part of the record for them to develop further. And since they declined, they would be responsible for any result or decision which I provided to them thereafter, which might have been inconsistent with a part of the collective bargaining agreement that they hesitated to provide to me. Arbitrator notice. Taking notice is simply utilizing information which is not on the administrative record, not on the arbitration record, to come to a conclusion about facts or a conclusion about the law. There is so much information out there, a lot of it's on the internet or elsewhere, that relate to some of the factual questions which arise in a contested arbitration proceeding. The parties, the advocates, can only get so much into the record. Sometimes they don't get enough into the record, and sometimes they don't address a particular topic that the arbitrator will find after the record is closed is important. So, should the arbitrator ever take notice of facts or information that was not actually presented or discussed on the hearing record? An arbitrator should not be and is not an investigator. Arbitrators should not go out to the internet to attempt to determine how much money Company A made last year for its shareholders. Generally, when an arbitrator takes notice of a fact, it is something that would normally not be in dispute, or there is normally not a divergence of opinion about what the fact actually is. For example, if we were dealing with an allegation where it became important to know whether or not a particular action by an employee occurred during the work week or during the weekend, the record might only show that it occurred on April 13th. After the hearing is concluded, the arbitrator might say, hey, I need to know whether April the 13th was on a Monday, Tuesday, Wednesday, or if it was on a Saturday or Sunday. The arbitrator could go to the internet or to a calendar and could find and conclude a fact which was not actually a part of the hearing record. And I don't think that would normally be problematic. It would likely be much more problematic if the arbitrator went out and attempted to find a fact that allowed the arbitrator to reach a specific conclusion where the parties were not willing and able to quickly acknowledge the accuracy of the information upon which the arbitrator relied or wanted to take notice. The arbitrator is only one of the actors or players in the arbitration or contested hearing process. Another important set of actors are the advocates for the parties in the hearing. And as a part of the control of the hearing, conduct of the hearing, the arbitrator has to utilize those advocates. And so the issue or question arises, what should an arbitrator expect of the advocates who appear before the arbitrator in the hearing process? I like to think that the advocate should assist with the control of the parties and the witnesses. This is especially true if the parties and witnesses who require control are the parties and witnesses represented or offered by the advocate. I think it's appropriate, and the arbitrator should be able to expect the advocates to present and provide a history of relevant past practice. Especially in labor arbitration cases, there are prior interpretations of contract provisions which hopefully are consistent. They need not be consistent, but they're there. And an arbitrator coming into a case, unless that arbitrator has routinely heard cases for this particular employer over time, is unaware of this prior past practice or precedent or whatever you want to call it. And it's not readily available to an arbitrator to find. It's not something that would be in a casebook or on the internet. So the arbitrator should, in my mind, reasonably expect the advocates, if there is relevant past practice, to outline and discuss that as a part of their advocacy on the record. The arbitrator should expect that the advocate present his case, the evidence and the testimony from the witnesses, in a logical and coherent manner. The arbitrator should expect that the advocates would make a meaningful and accurate closing statement, whether it's oral or written. After the hearing is over, sometimes the advocates will submit written briefs or statements, and that's very helpful to an arbitrator as the arbitrator attempts to move away from the hearing process and start writing a decision that would affect the outcome of the case. And this also especially helpful because sometimes during the course of the hearing process, the position of a party or the position of an advocate would have moderated or changed, and that would be reflected perhaps in a final written or closing statement from the advocate saying, here's where we are in this case, here's what we showed, here's what we want. And so again, I believe the arbitrator should be able to expect some sort of summary of the case from a party or the party's advocate, which would help the arbitrator summarize in his own mind or her own mind the case and better understand what the actual issues are that survive the case hearing process. Finally, I think it's only reasonable that arbitrators should be able to expect that the advocates demonstrate professionalism, civility and integrity, and competence. And it doesn't hurt to throw in a little honesty. Now, professionalism, I think, is something that I have a right to expect of the parties, especially if, of the parties' advocates, especially if the advocate is an attorney. Civility certainly helps the hearing or arbitration process along, and it is crucial to maintaining control of the hearing process. I think that the advocates, especially if they're attorneys, should show some integrity. They shouldn't lie. They shouldn't be unnecessarily unfair in terms of how they present the case. And in other words, they should be competent. They should know what they're doing, and they should have some sort of theory of the case rather than throwing lots of facts and information and witnesses on the record for me to try to understand and decipher. They should be able to put together a theory of the case which I can understand and pick up on. And finally, honesty is always something that I appreciate when I see advocates appearing before me. I understand that honesty has to be tempered with presenting the best interests of a party that the advocate represents, but I think that as an arbitrator or a judge, I have a reasonable expectation that the advocates will not mislead me or develop information on the record that the advocate knows to be untrue. Not every arbitration case leads to a slam dunk decision. I like to view the process as the responsibility of the arbitrator, or the mandate of the arbitrator, is to provide a fair hearing experience. The goal of the arbitrator should be to make a decision which is consistent with the evidence and contract, which is still fair and just. Now, if an arbitrator accomplishes nothing else, the arbitrator needs to make sure that the hearing process itself is fair. If the arbitrator does not control the hearing process to the extent that the hearing can be regarded as a fair experience, that arbitrator is probably not long for this particular profession. Even if you disagree with my decision, you need to be able to walk away from that hearing thinking that you have received a fair hearing experience. As I indicated, the concepts of fairness and justice are not always what will be the ultimate outcome of a hearing process, but you don't want to have a party believing that your decision is inconsistent with the evidence and the contract. And to the extent that a party will agree that your decision is consistent with the evidence and contract, then you're a long way along the road to the point where a party will think that the outcome was fair and just as well as the hearing process. A third general topic which I'm going to deal with in this particular first part of the presentation today is dealing with bias and conflicts of interest. I like to think that the first step toward achieving an impartial and fair decision by an arbitrator is an honest self-appraisal. The parties will appraise an arbitrator and attempt to determine whether in their mind they think an arbitrator is fair and impartial, but the arbitrator, in order to have the best possible opportunity to achieving a fair hearing process, needs early on to take a look at him or herself and do a self-appraisal or self-assessment about bias and fairness. And what should be in the arbitrator's self-appraisal? The arbitrator should take an inventory of his or her own personal biases. We all have biases, and I think that in light of the case as presented, we need to step back and say, do I have a bias in an area that impacts upon my receiving this case and providing a fair outcome? Even if I have a bias, is it possible that I would be able to control that bias or to accommodate that bias to the point that I could get to a fair decision which did not necessarily reflect my bias? In the same vein, the arbitrator needs to say, well, do I have any actual or possible or apparent conflicts of interest? And most arbitration associations, when they refer out cases, will routinely ask the arbitrator to make this particular assessment. We're going to talk about the issue of conflicts of interest in terms of disclosure a bit later in a different segment of the presentation, but it is very important that to the extent that you are aware of the nature of a case, the facts of a case before you actually sit down and hear it, that you make an assessment of whether or not there's anything that you are aware of that would present a possible or even an apparent conflict of interest. When you're making that self-assessment, you need to attempt to look at the problem from the perspective of the parties. What is it that the parties might possibly want or need to know or deem relevant as they're trying to determine whether or not to accept me to be the arbitrator or to strike me from consideration as arbitrator in the case that they have approached me about or that the association has approached me about. Aside from this conflict situation, the arbitrator needs to make a self-assessment of the arbitrator's own competence. Advocates are not the only persons in a hearing who can be in over their heads on occasion. An arbitrator needs to take a look at the case as presented initially and attempt to understand whether or not the applicable laws or contract provisions or rules or positions of the party in the case are ones that the arbitrator is comfortable or feels competent to adjudicate. For example, if an arbitration dealt with some complex medical theories, the arbitrator doesn't have any experience in that area of practice, or perhaps it dealt with some obscure securities law provisions, many times an arbitrator might not feel particularly comfortable with a subject matter of a case, and if that's the situation, the arbitrator should recuse himself or simply decline to accept a particular assignment which has been offered. Now, I'm not saying that an arbitrator should reject cases where the arbitrator does not have an extensive experience or training. Arbitrators, especially arbitrators who are attorneys, generally have the ability, with the help of the advocates, to educate themselves during the course of the hearing to understand applicable law, to be able to interpret contract provisions, this type of thing. But if you are the arbitrator offered a particular position as a part of your self-appraisal, you need to ask yourself, is this a case that I am competent and comfortable handling? Or is this a case that I could get up to speed on and handle at a professional and adequate level? Because certainly no arbitrator wants to get involved with a case where it's clear he or she is in over their heads, and that will come back to haunt them in terms of their reputation further down the road. Another subject, and it's particularly important when you're dealing with topics that relate to biases, your own background. It's perhaps particularly important when you're dealing with situations where there may be some implication or question relating to race or some other demographic type of factor. It's important to be able to issue decisions which are fair, just, and sometimes it becomes an issue in terms of whether or not you are able to get beyond your biases or suspicions. In the process of issuing decisions following a hearing, the arbitrator is sometimes faced with the problem of issuing decisions which the arbitrator, him or herself, may not feel would lead to a fair or most just outcome. In other words, if I ruled the world and if I was sitting in a court of equity, how would I decide this case? And sometimes you have to be aware of any bias that you would have that would impact on how you look at a case. This, as I've suggested earlier, quite often surfaces when the record and the contract or the statutory language for interpretation supports a conclusion contrary to the arbitrator's own suspicions or experience. As you sit and hear a case, you may suspect that there is something going on that doesn't get into the record. As you sit and hear a case, you may suspect that one party who has been alleged to have been a wrongdoer in some way on the record may actually have been that. You may suspect that, but the record doesn't itself support that. And examples of this type of dilemma or need to step back and make decisions which are free of bias or suspension. Examples of this arise in an area where an arbitrator makes a decision perhaps with racial implications which may be inconsistent with the arbitrator's own racial biases or beliefs. In addition to the topics which we have also discussed thus far relating to conflicts of interest, it's important to realize that there are systemic biases which work against impartial adjudications and decision making in arbitrations, and these impact almost all arbitrators. And what are some of these systemic biases? Well, the arbitrator has to deal with an inherent pressure or temptation to please the parties, especially in situations where the parties can impact upon the arbitrator's future selection and or compensation. This kind of goes along with the concept of providing customer service, viewing the parties as customers rather than as litigants or parties before the arbitrator who are expecting a neutral, unbiased, and objective decision. Sometimes this will appear also because the arbitrators are responsible for deciding things such as the allocation of costs and fees of the arbitration, including perhaps the costs and fees of the compensation of the arbitrator. As I indicated earlier in this presentation, arbitrators are judges for hire, and as judges for hire, sometimes they regard themselves almost as being either employees or service providers, and if that's the case, then there's this issue about whether or not they need to take into consideration to some undue degree pleasing the parties who appear before them. And this will be discussed in other parts of this presentation, other segments of this presentation. Justice for sale. Money talks. Money is important. Arbitrators are in this business to make money. The parties are in this business trying to protect money or make money. So you need to be mindful of the role that money can play in the decision-making process for an arbitration. Arbitration is not necessarily cheaper than litigation. We often hear the saw, people go to arbitration because it's cheaper than going to the courts. That's not necessarily true. Perhaps that's true sometimes when you're dealing with business-to-business disputes or arbitrations, but when you're dealing with individuals, perhaps an agreement situation, arbitration is not necessarily cheaper than litigation because much of the expense of the litigation for an individual is underwritten by the citizens in the way of taxes. The judges are free. The filing fees are much less than the filing fees that you might see in an arbitration situation. Arbitrators are mindful of who may make decisions in the future to select those arbitrators. Sometimes it's not just this particular case that an arbitrator will be looking at. An arbitrator may say, I would like to get a lot of cases from company X. I know they have a lot of arbitrations. Do I dare issue a decision which may be repugnant to company A to the extent that in the future when they see my name they will automatically strike me and not consider me? Sometimes an arbitrator will have subconscious worries that the costs of arbitration and the fees, including the arbitrator's fee, may not get paid if the ruling goes against one party or the other. These are all types of systemic considerations that could impact upon the arbitration decision-making process. Touching very briefly on the topic of default arbitration hearings, I have been involved in the past with arbitration hearings which were offered by some of the associations to members of their panels, and these were basically collection cases, disputes involving perhaps telephone companies, cell phone companies and their clients, and in their contracts these cell phone companies may have put requirements that any disputes, including disputes about amounts owed, would have to go to arbitration rather than to litigation in the courts as regular collection actions. And in part that was because these companies saw the benefits of arbitration to provide possibly a cheap way to dispose of these collection cases, and they worked out situations with some of the associations which made them cheap methods of disposition of these collection cases. The arbitrators involved got paid relatively small amounts for each arbitration, the arbitrators could justify reduced fees because these cases were assigned by the dozen, and you could do them sort of like in your free time, during your lunch, late at night at home. And that was in part due to the fact that the collection arbitrations routinely resulted in defaults. The parties who were being charged with failure to comply with the contract would often not appear. The parties may have been several hundred miles away from where the arbitrator was sitting to decide the case, in his office or in his home late at night. And so 99% of those cases got defaulted, and these were essentially paper mill defaults where there was no testimony or evidence at all, and the arbitrator, during the course of the hearing, actually confronted what I call the empty chair. There was not any witness for any party, and so the arbitrator only had to make a decision as to whether or not the party had been given appropriate notice of the arbitration hearing pursuant to the contract language between the cell phone company, for example, and the customer or the party. And once that decision was made that there had been appropriate notice, then the entire case hinged upon whether or not the party had appeared to contest the amount alleged, whatever. And that almost never happened. And so these were essentially rubber stamp cases, and it became a problem. In fact, some of the court that reviewed these cases found that occasionally, many times perhaps, the parties hadn't even been given notice of the hearing. There were serious potential violations of due process, which would be repugnant to any default arbitration process. So there's this issue of, as an arbitrator, do you want to get involved in default arbitration proceedings, and if so, to what extent? Now, I'm not talking about default situations where there actually is a hearing, the arbitrator appears, one side appears with witnesses ready to go, and the other side just decides at the last moment they're not going to bother contesting the case. Then I think, under the rules of most associations and under the provisions of many collective bargaining agreements or contracts, it is appropriate for the arbitrator to allow for a default. Although in a situation like that, rather than defaulting one party due to the absence of the other, I myself might require the party that appeared to at least put a skeleton case on the record so that I would have some basis for my decision making, my fact finding, other than the mere absence of the defending party. Well, that concludes the first segment of this presentation video. I hope that there has been some information in it which was helpful and useful to you. I hope that you will get an opportunity to look at the other two parts to this particular session or segment, which deals with issues faced by arbitrators. The second part of this presentation deals with the issue of what happens, or the issue of when the arbitrator gets sued or dragged into court. And then there is a fifth part of the presentation which would appear in the next segment, which deals with some of the issues and problems faced by arbitrators, especially minority arbitrators, relating to business and operational issues. And so hopefully you will get a chance to look at that. And the final and third part of this video presentation, part 3, I'm going to talk about what I consider to be very meaty and important topics or issues, one being disclosure issues generally and how that would impact upon you, how it has impacted upon me in the past. And I'm also going to talk about race and ethnicity considerations in arbitration. And I am going to be taking a position that race and ethnicity does impact upon the arbitration process, that people of different race and ethnic backgrounds will approach an arbitration proceeding, fact-finding, credibility assessment in slightly different ways. And I'll hope that you'll take the time to stay and to look at those particular parts of this presentation when you have the opportunity. I do want